Shawn McBride with you. Today I want to do a little primer on drafting your own contracts. This may be something that comes up in your business. To be honest, for a lot of small businesses, at different points it may be a necessity. As always, I'm going to advise you to get a lawyer involved. That is really a smart thing to do because these contracts can come back and bite you. And a lot of times people, when they have a problem, down the line, they wish they had done things better in the beginning. But regardless of how you're going to handle contracts in your business, this will give you some ideas about what you should do to set up those contracts, how you should form those contracts up, and what you should get into those contracts, right? So this will make you better, even if you're just the reviewer. Let's say you do have an outside lawyer you're working with. That's putting the contracts together. Knowing these key elements I'm going to teach you today will make you a stronger consumer, better able to review what you're seeing, a little more knowledgeable. So that's our goal. As always, our goal is education, information, teach you about the issues, but it's not a substitute for legal advice. Get an attorney involved, particularly if your contract's of any consequence, right? If you care whether the contract's performed, if you care about the money that's going into the contract, it's probably good to get it reviewed, make sure you're doing the right things. So we're going to jump into what the basic requirements of the contracts are. There's different ways of stating this, and you'll see it in different contexts. What I've chosen to feature today is excerpts from the Florida pattern jury instructions. And so what the judges have done, essentially, like they do with other jury instructions, they've agreed what the key pieces are of forming a contract is and what a jury should be told at a trial and what questions they should be asked if contract formation is an issue. So this will be good because, at least from Florida's standpoint, this is part of the review you'll most likely go through if that contract's ever tested. Contract law tends to be somewhat uniform across states. It's one of the more uniform areas of law. However, it varies, as all. And what's important in one state may be emphasized differently in a different state. They may have a different way of saying things, which is why it's always important to get good local advice tied into where you're doing business. And also, we won't get into it deeply, but another core issue is which state law governs your contracts and what happens if those laws disagree. Perhaps the law between where you're doing the contract and the law where you agreed to do the contract. If that is of interest to you, as always, drop some comments. When I see perhaps a significant number of people commenting on an issue, I will consider doing an additional video on that. So feel free to drop comments if that's something you're particularly interested in. Okay, let's look at the first element here of Florida contract law, or the pattern jury instructions testing whether a contract was formed, right? Because right now we're talking about, are we forming a valid contract, right? That should be kind of the first piece of this. If you want to write a contract, you want it to be enforceable, right? A contract, as they say, is not worth the paper it's written on unless it's enforceable. So you want to make sure it's enforceable. Of course, we're talking about written contracts today. Yes, there can be oral contracts. Sometimes oral contracts are not enforceable under what they call the statute of frauds. But regardless of whether it's a written contract or an oral contract, you're going to prefer a written contract in the event of litigation because then you can actually turn to it and see what it says. Oral contracts, to the extent they are enforceable, could well be a he said, she said situation, right? Each person is going to disagree perhaps on what the original terms were. You're rarely going to have litigation over an oral contract where everybody agrees on what they said orally. All right, so number one, essential contract terms need to be clear enough that the parties could understand what each was required to do. So you need some clarity here, right? You need some specificity. Does the contract say what you're going to do? You will build a house to these specifications. It may be different than you will build a house on a piece of land, right? Contract says build a house. It's pretty vague, right? Because you and I know there's a lot of differences in houses, right? Different sizes of houses, different quality, different construction materials, different architectural designs, right? So The contract terms need to be clear enough the parties know what each is supposed to do. How much is one person supposed to pay? What's the other person supposed to do? In most cases, that's kind of where a contract's formed. Usually there's a paying party paying cash here in the U.S. and developed economies. And on the other side is somebody that's doing something. They're providing a good or a service. It is certainly possible to have contracts service for service, a barter type situation. People trade services. A lot of newer businesses do that. So you don't necessarily have to have cash on one side and products and services on the other side. You can have products and services on both sides. You can also have a loan where you essentially have cash on both sides, cash now versus cash repayment. So there's lots of different ways you can form a contract, but both people need to know what each is required to do. They have to each give something of value, right? This is a screening tool here in the Florida pattern jury instructions that is making sure that it was not a gift, right? So gifts are a completely different situation. A promise to make a gift under general theories of contract law is generally not enforceable, right? If I say I'm going to give you something in the future in exchange for nothing, I'm just promising to give you a gift, that may not be enforceable. Now, if you get a detrimental reliance, I promise I'm going to give you something and then you go out and spend money or act in accordance with that, some courts might say that would change the equation, some state laws. But in general, there needs to be something of value on both sides. Now, we don't necessarily need to weigh the value. There's a theory out there called the Peppercorn of Consideration, right? So there's got to be something of value, something of value. They don't have to be of equal value. They can be of unweighted value. That's really for the parties to negotiate. But there has to be something of value on both sides of the equation, or else it could be viewed as a gift and may not be enforceable. And so this is exactly what Florida's asking its juries to determine when they look at these. And the parties agreed to the essential terms of the contract. So there has to be an agreement. They have to know what they're agreeing to, right? Then the parties have to get together and understand those essential terms. There has to be something of value going both ways. And then now they have to agree to the essential terms of the contract. And it's important here to look at the wording, the essential terms of the contract. There are times, particularly in purchase order situations, otherwise, where some terms may have been agreed to and some terms may not have been agreed to, right? That can be a litigation issue where all of the essential terms agreed to. But you can see here in Florida, the judges that are charging the jury, the ones that wrote the pattern instructions, they're saying the key is the essential terms of the contract were agreed to, right? So we've got to have what some other people call a meeting of the minds. And you want to really document that into a good contract, right? You generally want to put in there language showing it's a meeting of the minds. You're doing this, they're doing that, right? And you're really memorializing that everybody's agreeing. So really want to take a moment and look at that underpinning, because we do still see people that do their own contracts in particular that miss some of these essential steps, right? They don't document the value on both sides. They don't, or sometimes maybe there is a situation where somebody's going to give something. I'm going to give you a release. Well, what's the value going the other direction? Is there a money payment? Is there something of value on both sides, right? This can be missed in drafting a contract. So we got to understand the fundamentals before we start really getting into details. And those are your fundamentals for you. Contracts should memorialize the terms, right? So the written contract is generally viewed as the end point of the negotiation. In more complex deals and business deals, what we often do is a letter of intent. We send documents back and forth about what we intend to do, what we think the agreement will be, what it may look like, and we start working through points and get those points tightened up. And then once we agree to all the major points, then we write the actual contract. For smaller deals, private deals, selling a car, buying equipment, stuff like that in your business, you don't necessarily need those intermediate steps. But that contract should show you what those terms are and what you agreed to, right? That's the whole point of having a contract, right? So let's make sure we hit those key points we just gave, those three elements from the Florida jury charges, or whatever the relevant authority is in whichever state you're forming your contract under. And then you need to memorialize those terms in the contract of what everybody's agreeing to. You want it to be understandable. There was a time where lawyers used to use a lot of Latin terms, used to really make things complex, very formulaic. In the modern era, more and more people are trying to draft in plain English. It's certainly something we strive for in general at my law office. But you want your contract to be understandable, right? You want to be able to, each party should know what it says. And importantly, somebody picking it off the table should be able to understand what it says, right? That's important in enforceability. When you end up in front of this mythical judge or jury, possibly sometime down the line, will that judge and jury understand what you said? Will they be able to pick it up and look at it? Or will you be in a situation where they are confused? And if they're confused, then you don't know whether they're going to give you the desired outcome. If they don't understand what the other side of the contract was supposed to do, if it's a performance of a service, if they don't understand exactly what service you were supposed to get back, they may well find that you weren't entitled to what you thought you were, right? That's why you want this stuff to be crystal clear to the extent you can get it there. Also, and this is something I see a lot in smaller company contracts, particularly LLCs, maybe small corporations, you got to consider the parties and you got to see who's agreeing to be bound, right? Who is allowing themselves to be part of this contract? So we take and we got to consider that very carefully. Make sure that it's the right person. You know, if it's an LLC, you generally want to bind the LLC, not the individual who owns the LLCs. But sometimes people get careless about that, right? You want to use the LLC's name, the LLC's address. You have the LLC signed by an appropriate authorized person. So usually what it'll look like is LLC signed by and the name of the person and their job title, right? That by line is very important. Sometimes you'll want to guarantee. Maybe you'll say, hey, I'm not happy just that it's an LLC. I want to know that the owner's going to back it up financially because maybe it's a newer LLC. Maybe LLC doesn't have a strong financial standing. But you want to agree who's being bound to the contract and what those terms are. And then get the correct signatures on there. If you're having somebody sign for the LLC, you got to make sure the person signing on behalf of the LLC is authorized, or you may have an enforceability issue, right? So is the person signing, does it look like they have authority to sign for the LLC? For more important contracts, you may want to look at their company documents. Are they authorized to sign? You want to dig deeper to get those correct signatures on those documents. So you want to really, really dot I's, cross T's, because when somebody's upset about the contract, I will tell you, everybody signs the contract, they usually forget about it, and this happens with LLC agreements too. And then when a problem arises, everybody runs to their files, pulls out the contract, and starts reading what it says. And this is when you want to make sure, if you're on the side of wanting to enforce the contract, you got to make sure the right people signed it, it's enforceable. So get this done correctly at the beginning, get the right people to sign the contract. Use formalities to the extent you can. Use proper names. Use what they call defined terms. If you use a term once, put it in quotation marks, define it as something, like XYZ Corporation, comma, a Delaware Corporation, XYZ. And then you would always use XYZ throughout, right? And you want to think about having things like what they call a merger clause, to bring all other agreements into this one agreement. Choice of law, choice of venue. If you want to talk about boilerplate provisions in contracts, again, drop me a comment, something we can possibly do a video on. But you want to use those formalities in your agreements to make sure that everybody is understanding what they're agreeing to and that there's no technical outs or issues, right? So the best you can do is to get formalities into the contracts. Don't necessarily need to have a lot of formalities to have an enforceable contract, but to have more formalities, more structure, will potentially make it easier to interpret and to enforce that contract. And then I also want you to what-if game from the beginning. What happens if something goes wrong? What is that flow going to look like? If you pay the cash and the person that was supposed to provide the goods or service doesn't provide the goods or service, what happens? How do we get from where having paid cash and not gotten the goods and service to getting to whatever the outcome is, getting a refund, getting a refund plus, getting somebody else to come in and do the goods and services. What is the path from a problem in the contract, something going wrong, to you being in a situation where you're at least comfortable, right? You're usually not going to be happy if a contract gets broken, but you need to consider what happens and what that path is. And that may update how you word the contract before it's even signed. All right, folks, it's educational just for you to get better acquainted, but contracts are important things. They are something that is a bedrock of businesses. Most businesses will end up signing lots of contracts throughout their life and existence. For things you do routinely, you definitely want to get form contracts, your regular sale of your goods and services, customer relationships, etc., etc. Get all of that documented with some type of form that you'll generally use over and over again. But for all your other situations, the unique ones, the buying equipment, purchasing a piece of land, all these things, you really want to be careful what you're agreeing to, and you really want to get it drafted right. There's some key tips here. Again, this can be very important because if you want that contract to be enforceable, you want it well written, and you want it to make sense to the jury. You want it to foreclose any technical issues, and you want to make sure that you can then enforce that contract if you need to. That's why I always recommend getting some additional help when you're getting these contracts drafted, because there are little things in there that can make a big difference, and you want to get them right. All right, folks, I'm Shawn. Hope you subscribe to the channel. Drop some comments below. Would love to hear from you. And I always take questions. I look at the comments, so if there's stuff that you need that we're not covering here on the channel, let me know, and I might consider it covering it in a future video. Look forward to hearing from you soon.